We are live.
And we have quorum, right?
Yep, you're good.
All right, excellent. Sorry, the House members got here before the Senate members did. Anyway, all right. Well, welcome everyone. Today is Wednesday, March 31st, 2021. We have 10 bills on the docket. We'll start off with Delegate Grammer with House Bill 253. We'll then go to Delegate Dumais, 505, 681, House Bill 931, 1008, 1153, 1186, 1248, 1339, and 1250 with Delegate Malone. So we'll start off with Delegate Grammer. You're up first with House Bill 253. Welcome.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 253. House Bill 253 alters the definition of a community association for the purposes of seeking relief for nuisance abatement in Baltimore County. It does so in several ways, such as striking the membership requirements and payment of dues by members. The nature of community associations has changed in Baltimore County. Today, we see significant participation and volunteer activity. However, we seldom see payment or collection of dues. The changes in this bill will help us address the growing problems of blight in communities of Baltimore County by adjusting our laws to the changing nature of community associations. A few brief facts before I close. You might recognize this bill. This was Senator Sidnor's bill. We've worked on this bill for at least 4 years. This bill passed the full House in 2019, passed the full Senate in 2020, but never the same chamber and both chambers in the same year. This bill is in the same posture as last year. So I would close and ask you please help us address the growing issues of community blight by passing this bill in its current form. Thanks for the hearing for House Bill 253. I'm happy to take questions and I'd ask for a favorable.
Excellent. Thank you, Delegate Grammer. We have a question from Senator West.
Thank you, Mr. Chair. I hate to say this, Delegate Grammer, but I hate this bill. And let me ask you, pose you a hypothetical, which will show why. So we have an organization which has formed that's called the Greater Baltimore County Community Association.
Okay.
Its bylaws provide that its boundaries coincide with the boundaries of Baltimore County.
Okay.
It has 2 members. Mr. Abel lives in Essex. Mr. Baker lives in Catonsville. And now under the guise of this organization, Mr. Abel and Mr. Essex file suit against a fellow who lives in Towson, alleging that he has committed a nuisance.
Right.
Why should we want to enable an Essex resident and a Catonsville resident to form an association for the purpose of suing a resident of Towson for a nuisance?
So I'm following you, but I don't think that's actually legal under the bill, nor is it what the bill does.
Explain why.
So the bill requires, the current law and the bill, if passed, would require the violation to be within the bounds of the community association.
But under my hypothetical, it is. The boundaries of the community association coincide with the boundaries of Baltimore County.
Well, there are regulations that dictate how community associations are formed, and I don't think the county would ever in any case say, okay, the entire community association or the entire county is a community association.
Under your bill, the county has no say.
But there are guidelines for the formation of a community association, and
your bill wipes them out. Under current law, if you look on page 2 of your bill, under current law, a community association must be comprised of at least 20% of the total number of households as members, with a minimum membership of 25 households of a local community that consists of 40 or more individual households as defined by specific geographic boundaries in the bylaws. Your bill eliminates that language and therefore enables Mr. Abel in Essex and Mr. Baker in Catonsville to file a lawsuit against a fellow in Towson.
So if you read it on page 2, line 7, it actually says residents of a community defined by specific geographic boundaries in the bylaws or charter. So in other words, when the private community association formed, it would have to specify the boundaries of the actual.
Under my hypothetical, it has. The boundaries are the boundaries of Baltimore County. And it calls itself the Greater Baltimore County Community Association. My question really comes down to, why didn't you try to deal with the language on page 2 and from lines 3 to 6? If you don't like 20% of the total number of households to be a member of this community association, reduce it to 10%. But what you've done is eliminate the limitations entirely so that a fellow in Essex and a fellow in Catonsville can form an association and can file suit against some guy in Towson. I just don't see why that makes any sense at all.
So I think, and this might not happen in your area, but what tends to happen in communities on the east and west side is that community associations used to charge dues, and we don't do that anymore. And frankly, the communities with the biggest problems are most frequently the poorer communities. I've helped form my community association in Essex. I wouldn't say we're an especially poor community, but even we don't charge fees. So the establishment of a...
Let me interrupt and ask one final question. Would you have a problem if we tried to pass this bill, but we re-imported some of the language from lines 3 to 6 on page 2 to provide some sort of definition of a community association which makes some sense and requires it to be a group of people who are who live relatively close to each other rather than at two far ends of the county?
Well, respectfully, Senator, I'd object to that amendment, seeing as how we passed this in the full Senate last year. And I do so on the grounds that a hypothetical where a court would allow an organization just to define itself as countywide, it is more of a hypothetical. And the practical use of the bill in question, if passed, is a realistic use of communities that do struggle with massive community blight issues. And the principle of the matter is that we just don't have any money. We don't charge people. We operate on volunteers. And that's the premise of loosening of those percentages.
Okay, I think I've gotten the answers I need. Thank you very much, Delegate Kramer. I'm sorry to subject you to.
It's okay. I appreciate the questions. Thank you.
Excellent. Thank you, Senator West. Looking to the committee for additional questions. Delegate Kramer, welcome to JPR. Don't take it personally. He's going to spend the better part of our evening session kicking me around the Senate floor over police reform, and he hates that bill too. So equal opportunity. So welcome and thank you for your hearing and your testimony. And with that, that'll conclude the hearing for House Bill 253. We'll now move on to Delegate Dumais with House Bill 505. And I think, Madam Vice Chair, you have two witnesses with you. And
I believe so.
Okay, great.
At least I see one that I know is in favor. But anyway, good afternoon, Mr. Chair and esteemed members of the Judicial Proceedings Committee. It is my pleasure to be here this afternoon to talk about this important bill. The legislation is the result of the Commission on Child Custody Decision-Making, which was established by the General Assembly in 2013. It was tasked with studying child custody practices and policies in Maryland and making recommendations based on its findings. If enacted, this would create a custody statute that provides a clear, predictable, and consistent guide, I think, for parents, lawyers, and for the courts. As part of that same commission, the Maryland Judiciary Rules Committee approved in 2019, and they became effective in December of 2019, new rules for parties in contested custody cases. That commission was probably the most comprehensive commission I've ever served on. There were about 25 members, but we had subcommittees and invited other members from the bar, from mental health professionals, from the courts to come in. And in the subcommittees, we had a court process committee that actually decided to work on the rules that are now in place. So now, if you want to file a custody case before trial, you have to submit a parent. Each side has to submit a parenting plan. The rules and what House Bill 505 would do, importantly, is change the dynamics of custody determinations by using neutral positive terms. So instead of saying custody and visitation is a word I don't use in my practice. Only any parent just visits with a child. But we changed those terms from, instead of saying legal custody, we talk about decision-making authority. Instead of saying physical custody, visitation, or access, we talk about parenting time and how it's shared. I think the new rules, and certainly if we can get to a place where this is in statute, would be very important. The bill lists a total of 15 different factors for the courts, the parties, the parents, and attorneys to give thought to before they make decisions and when they're working through their parenting plan. The factors include things like significant regular contact with each parent. Actually, the bill provides that there should be significant regular contact with each parent, consideration of the child's developmental needs, the level of conflict that may exist in the relationship between the parties, the parent's psychological adjustment, and a child's need to maintain significant relationships, including with other members of the immediate family. The legislation specifically stipulates that neither parent is presumed to have any right to legal decision-making or parenting time that is superior to the right of the other parent. And the bill rejects the concept of a presumed schedule of parenting time. Each case, each family is different and should be treated that way. Court rulings concerning legal decision-making and parenting time must be guided overall by the best interest of the child. I think this would be a huge step forward for Maryland. I'm delighted that the House passed it, and I hope that the Senate will see fit to do the same. And with that, I'm happy to take questions, or if you want to hear the witnesses, and then you can ask all of us questions. I know Ms. Ruth, who is here to testify, also served on the commission, as did I. I believe Senator Lee may have, and Delegate McComas also did, and I believe that Delegate Malone might have been involved with it as well. So there were several legislators involved, in addition to the myriad of, there were over 200 people involved in this commission by the time we were all done. So thank you for your time.
Excellent. Thank you very much. And I guess we'll go on to Ms. Ruth, and then we'll hear from the opposition panel, and then we'll ask questions at the end. So Ms. Ruth, you're up next. Good to see you. Welcome.
Good afternoon, Mr. Chair, members of the committee. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. I don't want to repeat anything that Delegate Dumais said, so I just have a few points that I'd like to make. I really commend you to read the written testimony of the MSBA Family Law section, which also supports this bill. I was quite struck by how eloquent it was on the topic of sort of evolution and how our laws evolve and our statutes need to evolve with them. And one of the most important components of this bill, in my view, as a practicing family law attorney, is the update to the language that Delegate Dumais described. I can't tell you, of the literally thousands of people that I have talked to on our various hotlines and whatnot, who are self-represented, who start their conversation by saying, I'm involved in a custody battle, I'm in a fight, I'm at war with the other parent. And I really, really think that the language advancement that this bill provides, that is neutral, that tries to evolve the thought process behind contested custody or even uncontested custody, it would be a really, really valuable addition to our statutes. So that is a piece that has always been very, very important to me in the many years we've been talking about this bill. Please do read the Family Law Section Council's testimony. As Delegate Dumais also said, putting the factors that are now in a variety of cases out there that family law practitioners know how to find, use, read, refresh their recollection is not so helpful to the citizens of Maryland. And we really believe that it is time to put the custody factors that courts use into a statute, which is what this bill does. It did arise from that really comprehensive work that the commission did now going on, 8 years or something ago. And, it was relevant then, and we've been hoping and having some success on one side or the other, depending on the year down here. But I'm hopeful that this is the year that we could do that for the citizens of Maryland so that they have somewhere that they can turn to say, oh, this is what judges want to hear about versus this is what they don't want to hear about. I really think it would help focus cases. I think it would help the courts if there was a way that litigants, who so many of whom are not represented, could look at something and say, oh, these are the things I need to focus on when I'm testifying. So, beyond that, I know there is some opposition, but I think that by and large, you'll see that the testimony is widely in support of this bill, and we're hoping for a favorable report from your committee. And I'm also happy to answer any questions. Thank you very much.
Excellent. Thank you, Ms. Ruth. We'll go to the last, we'll switch over to the opposition panel, and we'll go with Mr. McAvoy. I see you. I kind of half see you over there. And then we'll come back to a question from Senator Lee.
All right, thank you so much, committee. I was putting because I wasn't unmuted yet. I strongly urge an unfavorable for this, and Chairman, I'll appreciate you hearing me on this. Am I coming in loud and clear?
Yes, sir, you are. We can hear
Thank
you.
you. Unfortunately, when this was heard in the House, there was the day of sleet, and I was unable to work out an alternate arrangement to testify that day. This bill is based on town hall that either me, and when I say me and my folks, I meant I incepted the National Parents Organization for Maryland. So either me or my team went to all of those town hall hearings. At the hearings, unequivocally, we heard the parents saying they wanted equal parenting time, which was an odd grassroots type of statement because this wasn't advertised very much. And primarily appearing there were industry insiders. Domestic violence people were there, family law attorneys that were there, radical gender professors were there. My issues with this bill have to do not just though with the genesis, but the application of where this is going to be applied. This is actually window dressing, but as it's going to apply to the day in, day out cases, this is not the bill that you want. This doesn't solve anything. And if you read through my testimony, you're going to see that this is just window dressing. It's going to allow judges to cherry pick by using what's now encoded to get the same exact results. And I encourage you all to look at through my testimony where it details the history in Maryland of tender year doctrine. That still happens to this day. Don't just listen to me. Listen to your colleagues. Listen to Senator Carter, now Senator Sidner, Senator Bishop Hughes, Delegate Smeagol, Delegate Darren Swain. Not only do they testify to this, they also tell about their personal experiences that they had. Now, for those parents out there who would actually like to get help, well, yes, the parenting plan changed in the Maryland rules in 2019, but you know what? If we really wanted to help these unrepresented parents, and I don't think we do. I think this industry likes breaking up family. I think this industry likes making $300 an hour billable. But if we wanted to, we could do something, as you see in my testimony, where I actually did that type of constructive free layout for the child support system. That could be done and put into the lobby areas of all of our courthouses all across the land in Maryland. That's what is needed, not this bill. I strongly urge you to read my testimony, click those links. I urge an unfavorable. Thank you so much, committee, for your time.
Thank you very much, Mr. McAvoy. And so I passed over Mr. Gladstone, who's on the proponent. You were up next. You're the last witness for the proponents. Welcome and thank you.
Oh, thank you. My name is Jonathan Gladstone. I'm a trial lawyer in the Office of the Public Defender. You may wonder what the public defenders have to do with this case, but I happen to be working in the Parental Defense Division, which is the division formerly known as the Synod Division, in which we represent parents who are encountering difficulties with the Department of Social Services and instituting court proceedings, which often involves the department taking custody of the children. My reason for participating is simply to ask that we ensure that this bill is not designed to have any effect on the SINA system, in that there may be a situation in which some of the principles might be analogous, but we can't assume that. So we would ask that you proceed as you wish. If it isn't clear already, it should be clear that any determinations of modifications of the decisions in SINA cases should be viewed on their own separate merits. And that's all I have. Thank you.
Excellent. Thank you very much, Mr. Gladstone. And so with that, that'll conclude the testimony for House Bill 505. We'll now turn it over to the committee for questions. Senator Lee, you're up first, and then we'll follow with Senator Castley.
Yeah, can you hear me? Thank you, Mr. Chairman. I'd also like to commend Delegate DeMay and also Lori Ruth and all the advocates that worked on this bill and also the commission, all the years that you devoted to this very comprehensive I think that this bill is extremely helpful for all the parties and all the courts who have to preside over in terms of these child custody cases. Adds more clarity and more direction. And I think that the bill took out, and you can correct me, Delegate DeMay, the weighing factors, the issue that the former JPR chairman had about weighing. So now I think the bill looks great, and I think we should move this bill out. And I think it's good, particularly for pro se litigants. So anyway, that weighing factor is out now. Of course, I think
That's correct. And in fact, the Judicial Conference supports the bill. They'd asked for two.
That is remarkable. Okay.
Every now and then, they had asked for two changes. One was to strike, which the House did by amendment, a place where it says asking the court to weigh each factor. I forget even where it came from. So as long as they're considering the factors, that's fine. The other thing is the bill does indicate that a court needs to articulate on the record the basis for their decision, including sort of a review of the factors. And the court asked that it read on the record or in a written opinion. And I was happy to add that. And so with those two changes, the Judicial Conference submitted testimony today that supports the bill.
Thank you very much, Delegate.
May, for Mr. Gladstone, this is a different section of the code, and Senate is not included.
Great. Thank you, Delegate.
Separate section, yes.
I
Right.
think this bill is ripe right now for going forward. Thank you so much.
Well, I appreciate it very much, and I appreciate you sponsoring it in the past.
Thank you, Lori Ruth, too, also. Thank you.
Excellent. And the letter from the judiciary is on your laptop. So thank you very much for that. Okay, Senator Cassidy and Senator West.
Yeah, thank you, Mr. Chairman. Delegate DeMay, good to see you.
Nice to see you.
I just want to commend the House for this. You obviously as well, but I'll just give credit to the whole House as well for
Sure.
extensive preparation. I was impressed by the collaboration with the numerous experts and the people on both sides to really not just have this as a legislative driven initiative, but people in the experts and the folks involved. And I understand this was bipartisan, and I look at the bill, it's a nice logical flow, that's a fair process and really protects the interests of all. So here's my only question is, how could the House that produced this very nice piece of legislation have also handed us House Bill 670?
I am the wrong one to ask
Okay.
because
Okay.
I unfortunately agree with you.
Everything I just said about yours, I cannot say one of those things about 670. Delegate, you have a nice day. Thank you very much.
Thanks. You too.
I saw that one coming. All
I
right.
bet you did.
Senator West, go ahead.
Well, I could say the exact same thing, but I won't. Instead, I just want to commend Delegate DeMay. I just think we are so lucky down here in Annapolis to
Oh
have
my goodness.
as one of the state leaders in the family law area. She knows this stuff backwards and forwards. She spent her whole
Thank you.
career on it. And we are so fortunate to have someone with that level of expertise in the General Assembly who can bring us an excellent bill like this. Thank you.
I appreciate that. Thank you all very much for your comment.
Keep this one for the record books. All right.
Amen.
With that, seeing no further questions, thank you very much. That concludes the testimony and hearing for House Bill 505.
Thank you.
Thank you very much.
Thank you all very much.
You are.
Have a good afternoon.
Thanks, you too. All right, next we'll move on to House Bill 681 with Delegate Buckle. You're up. Good to see you.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. It's so wonderful. I'm looking across my little Zoom screen and realizing almost all of the members of the committee, with a few exceptions, I had the pleasure of serving with in the House of Delegates, some as recently with Senator Jackson, it's even earlier this year. So it's great to see all of you. After watching that last bill hearing, I would also like to say that I think this bill really is a product of Delegate DeMay's good thinking and hard work. And so, I'd like for my bill to also be viewed as Delegate DeMay's bill, because obviously that was a great statement. My bill passed the House last year. Last year, as you know, in the House, unlike the policies you've adopted for COVID during this session in the Senate, in the House, we cannot have co-sponsors for the bills in this particular year. Last year, this identical bill passed the House, and it was co-sponsored by myself and Delegate Vanessa Atterbury, the Vice Chairman of the Judiciary Committee, in a bipartisan fashion. We sort of co-sponsored it together as primary sponsors. This year, given the restrictions on that the House imposed, the bill is solely under my name. As some of you know, probably most of you know that practice law or pay attention to these types of issues, our orphans courts in Maryland are a strange anomaly. We have different rules and different setups from different counties. In Montgomery County and Harford County, there is no elected orphans court. The de facto orphans court for will and estate disputes is to go to the circuit court, as you would for a wide variety of other civil matters as the court of first jurisdiction. In Baltimore City, Baltimore County, and Prince George's County, over the years of development of the law, each of those counties has previously sought a constitutional amendment that is now in our constitutional law that has created an orphans court for their counties where judges are elected, but they are required to be attorneys, so that they have to have those types of prerequisites that we have for any other type of individual in our system who calls themselves a judge and who adjudicates cases of law under the Estates and Trusts article in this case. In our other 19 counties, ranging from counties as large and complex as Anne Arundel to as small as Kent and Caroline and Garrett, the smallest counties in our state, we elect orphans court judges every 4 years on a partisan basis. They identify themselves as Democrats or Republicans. They are elected as such, and there is no requirement that they be attorneys. And in most cases, I haven't done the research to conclude in all cases, but in almost all cases, they are in fact not attorneys. So if you have a complex estate dispute and situation in Montgomery County, you immediately file that and proceed before a circuit court judge. If you're a few miles away in Howard County or Frederick County, your court of first jurisdiction, so to speak, is the elected non-attorney, typically orphans court, from which then you have certain appellate rights or waiver rights that could get you to circuit court. I don't know and wouldn't presume to suggest the perfect answer to that problem. I think it's a little bit of a complicated question. It has a variety of stakeholders. I don't think it's susceptible to being resolved while we're down here doing so many other significant things in the 90-day session. And as a result, Delegate Atterbury and I last year, and again concluded this year, that perhaps it would be best to put together one of the famous task forces that would bring all the stakeholders together, including orphans court judges from both large jurisdictions and small jurisdictions, other stakeholders in the process, and would allow us to work on this issue and propose potential legislation. There may not be a solution. We may reach a conclusion that this anomaly works for enough people that perhaps it's not worth changing, but it certainly is an anomaly in the law. And it certainly is something that it's difficult to explain to families, to litigants, why they get treated differently and have a different process solely based upon where the decedent died or where the property was situated at the time of death. And that's the goal of the task force, is to give us some time and some expertise, like Delegate Dumais just talked about. She did in that family law context, to bring everyone together and see if we can come up with an acceptable solution for this conundrum. And that's it.
Excellent. Thank you, Delegate Buckle. Turning over to the committee for questions, seeing none. Thank you very much. It was great to see you, and we will be in touch soon. Have a good
Thank you,
afternoon.
Senator. I appreciate it.
Yeah, likewise. Have a good one. All right, with that'll conclude the hearing for House Bill 681. We'll now move on to Delegate Ericon with House Bill 931.
Thank you very much, committee. Mr. Chair, Mr. Vice Chair, happy to be here. I'm going to try and keep it short because I know you had a long night last night. I was trying to stay up listening, and then I actually fell asleep before you finished. So I'll keep it brief. This is a very simple bill, and I'll just sort of give you some background on how it started. There was a family in Harford County, and their son was in a daycare center, and he was molested by another child in the daycare center sometime around August or September. And the mother was not notified, even though they are mandatory reporters and they did report to the police. The mother was not notified until December. So her child was still attending, and the other alleged and substantiated victims were still attending the school, the daycare center, and the parents had never been notified of a potential sex abuse that occurred on the premises. So what this bill does is it seeks to remedy that. We already know that everyone in a daycare is a mandatory reporter. What that means is if you think something has occurred, you need to report it. This bill says if you get to the point where you think something has occurred and you need to report it, You also need to send a letter home letting parents know that something may have occurred. And that way the parents can get their children to treatment, because a delay in treatment, especially for a child who is a sex abuse victim, is really harmful. The little boy who this bill is named after, Aiden, has gone through a lot, and he's been working really, really hard to recover from what happened to him. But there are people whose children still attend this daycare and they do not know what happened. So this bill would not expose anybody. It would be anonymous still. You would not know the child's name or any parties involved. It would just say an alleged event may have occurred on this day. It is currently under investigation, and give them some resources so that they can get help for their children in case their children were potentially other victims or witnessed something that occurred. So that is all this bill does. There was no opposition on the House side when we heard the bill. I believe it passed the full House unanimously, and we are over here, and I'm happy to take questions.
Excellent. Thank you, Delegate. And we'll just switch over to the opposition panel, and then we'll take questions at the end. So we have Christina, Ms. Push, you're up next. The floor is yours.
Great. Thank you so much, Chair and the STEAM Committee. And thank you to Delegate Erica for championing her efforts in championing, bringing to light the importance of child abuse and neglect. I'm Christina Push, Executive Director of the Maryland State Child Care Association, and we did not get our testimony in time to put the opposition in with all of the virtual. We just didn't get it there. So we're here now to share our concerns. And our concerns include that this bill, although requires within 24 hours of alleged suspected abuse, that you are to inform all the families. So it could be hundreds of families that allegedly something occurred. This doesn't seem that it would be, it seems like, and then you have to also, it's requiring you to share contact information for the local child advocacy and other resources. Again, I don't understand how you could presume guilt before any investigation. You don't even have a chance to speak to the law enforcement or child protective services, and it would alarm families before even knowing that there is any corroboration. So we are concerned that it would have potential anxiety for children's families, probing of children and families, and without a full investigation or formal investigation, I'm not sure how anyone wasn't informed, but MSDE is required to be involved, and they are part of this as our licensing authority in Comar. So their protocols are to suspend the program or the provider should there be abuse. So if this is child to child, they have to work within the CPS and law enforcement to decide. And this bill does say it depends on what those experts say, whether or not to even make that recommendation or let parents know. So we are concerned about the presumption of guilt and the reputation and how that would impact children and families. So then that's why we oppose the bill.
Okay, excellent. Thank you, Ms. Bush. All right, now that concludes the testimony for House Bill 931. We'll switch over to the committee for questions. Senator Hedelman.
Thank you very much, Mr. Chairman. Delegate Eric, you mentioned that the child in the circumstance that you described was abused by another child. Can you just give me an idea of what the ages are of the children we're talking about?
Yeah, Aiden, I believe, was 5 at the time, and the child that abused him was 13. And they had placed a 13-year-old child, 12 or 13-year-old child at the time, into the younger classroom due to his developmental issues. I think he was on the spectrum. And Aiden was not the only victim, and it was caught on camera. Eventually, they caught it on camera, and there was definitely multiple victims. And it did go through the DJS process, and it was fact sustained. But it was terrible, and I'm horrified that a mother could go multiple months without knowing what happened to her child, even though the leadership of the daycare was well aware because they had already called the police. They are mandatory reporters. They did call the police, and they did call CPS, and no one was alerted. And this wouldn't necessarily, this bill, the way it's written, wouldn't necessarily make it for the whole school. It would be any child who could have been exposed to the act. So it could have been another victim or something. And if that's not clear enough in the language, happy to make it more clear. I'm certainly flexible, whatever the body's will is to tweak this so that but it should not be at the end of an investigation. That's unacceptable. Parents need to know what's happening to their children, especially if there's alleged sex abuse in any instance.
Okay. I'll have to take a closer look. I mean, I certainly agree that parents should know if something like that happens, but I'd be happy to talk to you about it more. Thank you.
Great. Yeah.
Thank you, Senator Hedelman. Now, Senator Lee.
Thank you, Mr. President, and thank you, Delegate, for bringing the bill. I think we're all very concerned about this issue, particularly the trauma that child has to go through. But we also want to make sure it's a fair process too. So can you just walk me through, is there an investigation done and then a determination of whether or not the incident actually happened? What are the procedures that are followed under this? I'm sorry, I need to look closely at this bill, but I know what you're trying, the intent is very good because we're all trying to fight with, molestation and child abuse. So what are the procedures and protocols that you go through?
So what's supposed to happen is if you're a mandatory reporter and you believe that an event has occurred, you are supposed, that person who first comes to the knowledge. So it's not like it's like if a teacher witnesses something, then they don't report it to their higher ups. They're supposed to immediately report it to the authorities. And then the authorities initiate an investigation into that. And what this bill would do is at that moment that they decide, yes, this should be reported to authorities, it's then going to trigger, yes, you should also send a letter home to any children who may be victims or may have been exposed to the alleged act. Just to let the parents know so that they can get their children potentially help as soon as possible instead of waiting multiple months. I mean, we all know how long a police investigation can go on. That is a lot of missed opportunity of helping children who have been sexually abused to get the help that they need.
Yeah, I understand that to protect child, going forward, but we're just addressing all sorts of sides on this as to, we just want to make sure that, the facts are accurate and that the incident did happen so that, perhaps someone who might be innocent might not, whole reputation maligned and all that. That's all I'm concerned. Maybe Christina, you can address that issue too, if you want to jump in. Christina.
Sorry, I unmute myself. Sorry about that. Yes, and I would say, Delegate Eric, this bill specifically says you have to notify all the children within the child care center. So all families, it says, have to be notified. So if you have 200 families, and this is 2 children that are involved in an incident, every family will be alerted about something that has not been fully investigated. And I understand that processes take too long, and I agree with you. I know that children's safety is our biggest priority. So I understand the intent of this. This could have unintended, far-reaching consequences to a child whose family then is involved. And this particular incident, which is horrific for Aiden, we've heard of other instances where child abuse has been alleged and not occurred between 2 children. And that 13-year-old, again, that might have been because of the special needs, was allowed to be in there. And the police and CPS investigate. They are high-level professionals. And so we take the lead from them, as does MSD typically suspends these programs, or it has a way of working, through the system to make sure that all of the protocols are in place so that the families that are necessary to know and work with are. So, this is an unfortunate situation on this particular person, but this has far-reaching impacts, this bill. And I'm very concerned, had we gotten our testimony in on time, we would have been able to share that on the House side, but it is incumbent upon me to share it with the committee now that this has possibly needs another look.
Excellent. All right. Thank you very much. And with that, thank you, Senator Lee, and thank you, Delegate Ericon. And with that, that'll conclude the hearing for House Bill 931. We'll now move on to Delegate Hill. There you go.
Yeah.
You're up next.
All right. Good afternoon, Mr. Chairman. It's good to see you again, Mr. Vice Chair, members of the committee. It's sort of funny. I am actually testifying here and in my HGO committee, and Senator West is in your committee testifying in my committee. So, Good times.
Make sure you give
Anyway,
him hell over there.
okay, as soon as I get off with you, I will. I can get back and ask him a whole lot of questions.
There you go. Yeah.
In any case, let me present to you HB 1008, failure to pay rent proceedings, sealing of court records. I mean, you certainly know probably better than I do that one of the motivating legislative policy initiatives of this session has been how do we deal with eviction proceedings, protecting the landlord and their rights to enforce their contracts, and the tenants who sometimes get caught up, and we've made special exceptions because of the COVID pandemic. But we also recognize that this issue of evictions and how the process worked precedes the pandemic. What this bill does that is different from most of the bills that we've looked at, it looks at the after effects of an eviction filing on the ability for people to get housing, to have reasonable credit, to frankly get an education, and how those kinds of negative effects of having a report of an eviction filing has repercussions well down the line for years to come, and can affect, you know, families, not just the adults, but also the children as well. And part of the reason for that is that in Maryland, once an eviction filing is put into place, it doesn't matter whether the filing is found to be sustained by the court, whether the person's evicted, or whether the filing is dismissed because there was a settlement or there was some reason why it was improperly filed. Either way, the tenant is labeled with the Scarlet E, and that goes on their record. And so what this bill does is it simply says, if you really weren't evicted, if you settled it, you don't get that on your record, that you have the right to ask, and the court can decide to seal a record of a filing of eviction, right? To try and make that distinction. Now, we recognize that if there is a series of filings, if someone has, I think the law says 3 in a 12-month period, that's a pattern that a future landlord does have a right to know about. So we make it clear that there's a time lapse between when you can request a seal and when a seal can go in place to allow for those folks to be identified and for their history to reflect the fact that there's some difficulty. But we also know that there are, I wouldn't say so much landlords, but managing organizations that use the eviction court system as a cheap way of doing debt collection, right? A cheap way of sort of pushing people to pay on time who may be late. We also know that there are people who can be late payers because they had a bad circumstance. Maybe they were sick for a while, lost a paycheck, so they're going to be behind for 1 month. It's going to take them a while to catch up. Sometimes there are people who are chronically late because they have a lease that says they have to pay on the 1st, but they don't get paid until the 15th. And instead of the landlord working with them to change that date, they're often going to be the chronic late. And for some, and there's lots written about this, a chronic late payer who always pays late also pays late fees. So there's actually more money to be made by allowing one of these people to stay in the rental unit than kick them out and try and find somebody else. So all we're trying to do here is to say, if you fall in the category where you actually pay, your people file against you all the time, but there's never a finding against you, you should have a right to have that sealed. You should have a right not to be labeled as a bad tenant and have that then impact your ability to get quality housing, to get inexpensive housing, to get a good credit rating, to get that better job, et cetera, et cetera, et cetera. That's what this bill tries to do. And we worked with the Maryland Multi-Housing Coalition to try and make sure that we're protecting the interest of the landlords at the same time that we're trying to achieve this goal. And we have a bill that they were the only opposition that they've come on board with as well.
Excellent. Thank you very much, Delegate Hill. We're turning to the committee for questions. I see Senator Castley has a question. And then Senator Hellman.
Thanks, Chairman. Hi, Delegate. My question is, how does this work with the foreclosing the right to redemption? If the tenant has been, has redeemed already 3 times. For example, in Baltimore City, on the 4th time, you could, they only get, I'm sorry, they get 4 shots on the right of redemption, and then it's foreclosed. How would a landlord be able to establish that they've had, that the right of redemption is foreclosed based upon the four times that they've already exercised the right of redemption?
Right, so again, we don't, so the ceiling, the time allowed for when you can request it is after a year has gone by, you can request that it be sealed, right? So for what you're talking about, where you're looking for within a 12-month period, you don't get to seal that record until enough time has gone to capture those folks.
Okay, I'm just confused because.
So it doesn't affect it at all.
Maybe you can speak, because on page 2 at the bottom, the
Let me
link.
pull the bill up. Let me pull the bill up.
Okay, I'll wait.
Okay, I'm trying to juggle a bunch of things.
Understand. We're all there with you.
We're all there with you. All right, let me go
Only
here.
give us one computer, that's the problem.
Yeah, I'm going over here. Let me pull up the bill. All right, here we go. I've got the fiscal note up, and now let me pull up. And I don't know if that addresses it at all. Let me look, and here's the bill. Oh, that's the outline.
I'm on page 2, line 31 to 34.
Okay, all right.
And perhaps I'm misreading this, but it says within 60 days after the final resolution of a failure to pay rent proceeding, the district court shall seal all court records relating to proceedings if the proceeding did not result in a judgment of possession and no appeal is pending. So
we'll look at the
doesn't
rest of it. Right, let's look at the rest of that. I'll pull it up now. And thank you for your patience. All right, so we're looking at the bill as passed the third reader, which was significantly edited. And you said page 4?
I was on page 2, at the bottom of page 2, line
Page 2.
34.
Okay, so within 60 days after the final resolution of a failure to pay rent proceeding, the district court shall seal all court records related to the proceedings if the proceedings did not result in the judgment and no appeal is pending. Okay,
Right.
It does not apply to any tenant against whom 3 judgments of possession have been entered for rent due and unpaid in the 12 months prior to the initiation of the action. If you look just above that. So those are the folks, that's the right of redemption.
Have been entered. Okay, but how would you be able to prove that a judgment had been entered if the records were sealed? I mean, I'm a landlord. I filed a rent collection action.
Mm-hmm.
The tenant redeems. And so now the tenant redeems, pays right, the day of in court, the tenant redeems. So I don't get a judgment for possession. And then, so there is no judgment that I was entitled to the money because they actually handed it to me in the district court right before the trial. So now they've paid. So that disappears from the records because there was no judgment entered. And the tenant does that 4 more times. And I want to foreclose the right of redemption.
Right. So the sealing does not mean that the court doesn't have access to the information, right? So you're the same landlord.
Yeah, I don't have access to it now.
So the record, no, so what it doesn't allow is for if the person were to move, right? And they redeem, then in other words, they paid it off and they moved, that it's that next landlord who doesn't have access to it. If you're the same landlord and they've done this 3 times and you're still in the 12-month period, right?
How do I prove that? Because how do I prove the filing and the redemption if I don't have access to the court records? I mean, how am I going to show that this is?
So if it's your renter, you don't know that you've done that 3 times, you need the court record.
I know it, but I can't prove it.
Sure, the court has access to the record. Sealing doesn't erase the record. I'm going to defer to the attorneys and to your committee, but my understanding and the way we work this through, this should not affect your ability. The record is still there. It is available.
Okay, that's so it is for intent. Okay, we'll go through counsel. Anyway, thank you very much.
So please, work it through. I think it's the right question. I think that it is addressed, but I am not an attorney.
No problem. We'll take a look at it. Thank you.
Yeah, I think I don't know if this will address, but if you look on the bottom of page 2 and the top of page 3, subpart G, and then on to page 3, to Roman I think that, and Roman I 1, subpart 1, subsection 1, I don't know if that speaks to what I was kind of half listening to what you were saying there, but that may speak to what you're talking about in terms of the timeline for sealing and the ability.
Yeah, I'm just looking at, because it says on page 2,
Yeah.
shall be sealed within 60 days after the final resolution.
Yeah, and no appeal is pending.
Right. So,
Yeah.
I mean, the foreclosing or redemption, if I file against a tenant and we're in court, the tenant has a right to just say, here's the money and we're done. But he gets 4 strikes at doing that. But if he keeps playing that game, then I can show the court records that I filed but okay, well, we can discuss it.
Right, and I will talk to, I mean, there were a couple of attorneys working with me on this who voted their bills in. So we're going to get a really specific answer for you. But I think, again, if this is a tenant who's always redeeming, right?
Yeah, always redeeming.
And you're getting that late fee, right?
Well, it may not be. I mean, yeah, you're right. I'm getting
You're getting the late fee,
but not my
right?
court
So
costs.
there's a
Because
lot
now
written there's a lot written in the landlord blogs and things about, but you're making more money off that tenant.
Not really,
So
because now I have to spend 60
So
of
if
the new
if I'm a
bills.
tenant, who is going to always be late, and you know it, but you don't give me the shift so that I can pay on the 10th instead of the whatever, and you're going to keep bringing me to court when you know I always pay, right? So to me, this is better than the one of the bills that said, let's just raise the filing fee to discourage the filing.
That's a different bill.
No, exactly. But my point is, we're trying to get around the same thing.
I
which
appreciate
is
it.
stop using the system to beat up on the people. Talk to them or change something. Or if you're getting your money, that means you're redeeming every time. Then why is this person going to be labeled? That's different than somebody who, there was a judgment and you settled after the judgment, so you ended up not evicting them. That's a different animal, right?
Yeah.
No, and I think that sometimes people are doing exactly what I think, again, good question. That's what we're trying to get at, right? There's a difference between people who don't pay, and you're taking to court.
Yeah.
And there's a finding.
Sure.
And
Some of
then
them have
they set off before they move.
Yeah.
Right. And people who are chronically late.
And others just put off to what they can do the last possible minute and play the game. So there's 2 different kinds, but I appreciate it. Thank you very much.
All right. Thank you.
Thank you both very much. All right, Senator Heldman.
Thank you very much, Mr. Chairman. So Delegate Hill, I noticed that you changed it from 30 days to 60 days, and I went and I looked at MMHA's testimony, and they really wanted 90 days. So this was a compromise.
Well, it wasn't. It was a compromise. What we agreed to do is ask the court. Their concern was that the courts wouldn't be able to keep up with it. It would become a problem. It would delay other proceedings. And so we talked to the Maryland Judiciary, and they said, no, 60 days works, 30 days doesn't work for us.
Perfect.
So it was a compromise based on the facts. And in fact, the Maryland Judiciary has 2 other amendments they're offering that we would encourage you to take. That just has to do with the implementation and when the notice of this change would go up on the website. So we've been trying to work with all the parties to come up with something that is workable and gets to our goal of not, shielding every tenant, but the ones who really are well-intentioned or get into a temporary difficulty.
I don't see any testimony from the judiciary. So if you have those amendments, it would be interested to, at least I don't see them in what we have.
Okay, I'll talk to Judge Morrissey and make sure that they are submitted. And I mentioned them in my written testimony, but we'll certainly ask Judge Morrissey to get that right into you.
And I'm just curious if AOBA, because they are also the other large trade association that represents landlords, if they weighed in at all.
We didn't hear from them one way or the other.
Okay, and one final question is, I know this is a somewhat different issue, but did you think at all about including credit reporting in this bill, or no? You didn't go.
Well, yes, we thought about it, and it produced its own problems because my understanding is that this does not automatically go into credit reporting, but if I think it would strengthen the bill because it's the credit that really is the issue. But in working on the bill, there wasn't an automatic nexus. But yeah, if there was something to prevent things from being, so the best we could do was to seal it. And if it's sealed, it doesn't tend to go to credit reporting that way. But yeah, if there's some way to do that, that would be great.
Thank you. I appreciate it. I think it's a good bill. Thank you very
Thank
much.
you. Thank you very much.
Excellent. Thank you, Senator Hedelman. And seeing no further questions, that will conclude the hearing for House Bill 1008. Thank you very much, Delegate.
Thank you very much, all of you.
Good afternoon. All right, next we'll go on to, I thought I saw Chairman Clippinger here. Is the chairman here? All right, we'll go to Chairman Clippinger, House Bill 1186. Mr. Chairman, you're up. I'm gonna ask him, there you go.
Good afternoon again. Thank you very much, Mr. Chairman. Members of the committee, this is House Bill 1186. This is an extension on effectively the gun crime audit bill that we passed last year. The Office of the Attorney General has found that they need another year, that it took them longer to gather the information than they would have thought because of the challenges related to the pandemic. So they're asking for another year, and that is what the bill does. How about that? I'd ask for a favorable on 1186.
Excellent. Thank you very much. Got your text message. So thank you. And now we have a question from Senator Lee.
Yes, thank you, Mr. Chairman, and thank you, Mr. Chairman, too, Delegate Kriplinger. I just wanted to, I think this is a great bill. I just want to know if it also could specifically track polymer 80s.
You know, I know that the Attorney General's office has already started work. My hope was not to greatly expand the scope. I understand that there's an interest from researchers at Johns Hopkins to also include incidences where a red flag order was requested. I don't believe that data regarding specific kinds of guns is really readily available. So I know that the information about red flag requests would be readily available. So I'm not sure that requesting on specific types of guns would necessarily be something to add. But go ahead, Senator.
Follow-up question to Senator Lee.
Yeah, Mr. Chairman, the reason why I'm asking this is because, you know, the polymer 80s are like, you know, the ghost gun issue. And that use in Baltimore City has gone up by, we were told 500%. So we thought that was something that we should be tracking, just so that we know exactly, you know, where they are, what they are, the demographics of you know, the use of ghost guns.
Well, again, I don't know that information is readily available. I don't want to do anything that would further delay the audit that is being done. So I'm not sure that I'd be supportive of that.
Okay, that's fine. We can talk about that later and moving forward on other things. Thank you, Mr. Chairman.
Thank you.
Excellent. Thank you, Senator Lee. Seeing no further questions for the chairman. Thank you, Chairman, Mr. Chairman. And with that,
thank you.
The hearing for 1186. Thank you very much. See you later this afternoon. All right. We'll now move on. Sorry, Delegate Adams. We'll go back to House Bill 1153. Delegate Adams, you're up.
Okay, thank you, Mr. Chair. And for the record, Delegate Chris Adams. I don't make a habit of reading testimony, but to be concise for you and thorough for the advocates, I bring to you House Bill 1153, which amends the law relating to the naming of certain professional corporations. Professional corporations are those entities that are made up of certain licensed professions like architects, engineers, physicians, and others. This bill only applies to professional corporations comprised of physicians. It does not affect other professions. Professional corporations file an application under the State Department of Assessment and Taxation for use of the corporate name. Under current law, if they're not using the licensed professional surname, the department is required to send the application to the licensing board, which regulates that profession for approval. The licensing board, in turn, is required to send it to the professional association related to that profession. In the case of physicians, the application is sent to the Board of Physicians, which in turn sends it to the Maryland State Medical Society, or MedChi. While this process is designed to protect the public from misleading names, in practice, it is not providing any such protection. Let me explain. First, there are very few corporate name applications which fall into this category. As the fiscal note states, there were only 2 applications received in FY 2020 and only 6 thus far in FY 2021. Second, even if the applications which were filed, the review conducted by MedChi and the Board of Physicians does not serve its purpose any longer. They are both concerned about being sued for restraint of trade violations in the event they deny the use of a name, since the statute asks physicians to decide what the name of other physician groups can be. This runs afoul of the Supreme Court decision in North Carolina State Dental Board versus FTC. After conferring with the Office of Attorney General, we have some amendments which we think bring them on board with the bill. As amended, if SSTAT receives an application requiring review, it will notify MedChi, which no longer has to approve or disapprove. Instead, it can take no further action or refer the application to the Department of Health, which does not have the antitrust concerns that the board does. In short, while we are amending the process, there will still be necessary consumer protections in the statute, but we are addressing some serious antitrust concerns that currently exist. Thank you for the opportunity to present the bill to you.
Excellent. Thank you very much, Delegate Adams. And turning to the committee for questions, seeing none, that will conclude the hearing for House Bill 1153. Thank you very much.
Okay.
Have a good afternoon.
Thank you. You do the same.
Right, next we'll have is Delegate Washington here. I see you here. There you are. Welcome. We'll start off with 1248. Delegate Washington, you're up.
Thank you, Mr. Chairman and members of the committee. For the record, Delegate Alonzo Washington here to present on House Bill 1248, which is a bill that will directly increase the level of transparency in police-involved settlements and lawsuits across the state of Maryland. This bill requires all departments to report details about any incidents that result in a settlement or judgment against the agency, including the age, gender, ethnicity, and race of everyone involved in the incident, including the officer, a description of the incident, including the date, time, location, and what actually happened, the dates that the civil action was filed and resolved, and the amount of the settlement or judgment awarded. This bill does not include any details in it about the case itself, or anything, or it doesn't have any identifying information for the victims or the law enforcement officer either. It's a simple bill. As some of you might know, I co-chaired the police reform work group in Prince George's County to look at the efforts of our entire county and what we're doing in our police department. And what we found is that we couldn't find this information at all anywhere. And it took us a long time to get the information from the Office of Law. We had a 6-month window of doing our research of the department. And what we found was that it took about 4 months for us to get that information. And that's just something that should not happen. And so this will create a database for these settlements. So with that, Mr. Chairman, I ask for a report for this transparency bill so we can know how much money we're spending on police involved incidents in the state of Maryland. Thank you.
Excellent. Thank you, Delegate Washington. Thank you for the bill. And seeing no questions from the committee, that will conclude the hearing for House Bill 1248. Thank you very much. Have a good afternoon. All right. Next, we will go to House Bill 1339. Let me see. Do we have Kevin here? Is Kevin here? There we go.
Good afternoon, Chairman Smith, Vice Chair Walsh-Stryker. Can you hear me?
Yes, we can. Thank you very much.
Okay, thank you. Sorry. Good afternoon, Chairman Smith, Vice Chair Walsh-Stryker, and members of the committee. For the record, I am Kevin Geistley. I am the Executive Director of the Child Support Administration within the Department of Human Services. And I thank you for the opportunity to testify today in support of House Bill 1339. This bill extends the effective date of House Bill 946 and Senate Bill 847, both of which passed unanimously during last year's 2020 legislative session, and we thank this committee for your support last year. The extension from October 1st, 2021 to July 1st, 2022 allows the department and the Child Support Administration to complete the rollout of our new child support system. Originally, it was anticipated that our phased rollout would be completed prior to October 1st. However, with the pandemic, some additional time was needed. Otherwise, we would face an increased cost as well as increased risk to update both the current legacy system for our child support as well as the new systems, so they would be compatible in ensuring consistency across all jurisdictions for customers. In summary, House Bill 1339 is a technical amendment to extend the implementation date from October 1st, 2021 to July 1st, 2022. And for these reasons, we urge a favorable report, and I'd be happy to answer any questions.
Excellent. Thank you very much. And seeing no questions from the committee, that'll conclude the hearing for House Bill 1339. Thank you very much. Have a great afternoon. All right, now for the final bill of the day, we'll have Delegate Malone with 1250. Delegate Malone, you're up. Welcome. Delegate Malone, we can't hear you for some reason. I know you're unmuted, but we cannot hear you. Still can't hear you. We'll give him a second to log on and then come back. Looks like if this goes well, looks like we'll come down here. We'll vote at 3:15 though for the committee. Just 3:15 will be a relatively short voting session. Anything short compared to last night, but it'll be shorter. I promise, Senator West. I promise. Give him a second here. Sandy, you helping him back in? Come on. We'll give it another 30 seconds or so, and then we'll just, all right, here we go. Let's see.
Do you hear me?
We can. Success.
Good. I don't know why this is the second time it happened. I just had to re-log in. What I said before and what I will say again is thank you very much, Mr. Chairman and fellow committee members. I'm here on House Bill 1250 looking for a favorable report. The genesis of this bill came about from two things. In 2017, Senator Riley and I introduced legislation to increase the share that a spouse receives whenever his or her spouse passes away and the person dies without a will. This was a tragic incident in the Severna Park area where after a long marriage, a husband died in a drunk driving accident. He was not the one at fault. It was thoroughly unexpected, and like 60 to 68% of Americans and over 50% of those over 55, they did not have a will. They had significant assets. And at the time, what that meant, as I recall, was she would receive 50% of the assets. And because there were parents, there were not children of the parties, but there were parents. And then I believe 15%. We bumped up that amount. It was bumped up again in 2019. However, if you go back and you look at our intestate statute, 3102 of the estate code, it's been about 50 years since it's really been looked at. So I'm going to raise sort of 3 points, and there are very likely others that should be looked at. One is the spouse. And although with this new bump up, as I recall, it was sort of done ad hoc. What's a good number? Is 15,000 good? Is 40,000 good? Is 100,000 good? How long should the marriage be? You know, currently the statute is it becomes unlimited after 5 years. Is 5 years the right number? And although we work very hard here, unfortunately, when it gets down to crunch time, sometimes we're sort of just grabbing at numbers. And this would be better if it was done through a work group. So in particular, there's one issue regarding the spouse. The other issue is currently under the law, actually, you go back up the tree and you actually go back up to great grandparents and come back down. And that means you could come all the way down to third cousins thrice removed if necessary. And there are heir search firms. You would say, how many people actually die in the circumstances? Well, there are heir search firms that are involved. Candidly, my recently retired co-owner of my building, that was his whole practice, was dealing estate cases tied through heir search firms. Now, and I'm not saying that's not the way it shouldn't be, but maybe it should be changed. In particular, this will be my third point. Under Maryland law, if you're a stepchild, you receive nothing. So a third cousin thrice removed maybe you're able to receive all of an estate, and it's somebody nobody knew, somebody that could have married the decedent. So this is the purpose for it to be looked at. I understand the Judicial Conference has weighed in. I've spoken to Holly of our council staff, and what I'm more than willing, and in fact, I've already asked her to go ahead and draft it to remove the provision providing for orphans court judges to be on. I understand their concern. Then the other concern that the Judicial Conference had was, who would staff this? We proposed that it be staffed through the administrative office of the courts. Checked in to see whether or not legislative services could do it. Then I called the person who I discussed this bill with, which happened to be Professor Valerio. And yes, Professor Valerio is the daughter of the former chairman. And she is the only Maryland barred attorney who teaches as a full-time professor, estates and trust in the state of Maryland. And she said, guess what? I'm pretty sure we can staff it either. In fact, she said they could staff it either through the University of Baltimore Foundation. So I'm planning on having an amendment done that it'll actually be staffed through there. This hopefully isn't a huge heavy lift for whoever wishes to serve on this work group, but it's needed because unfortunately, as I stated previously, there's a lot of people who never get around to doing their wills, and a lot of estates are resolved pursuant to our intestate statutes. And things have changed a great deal over the last 50 years, and I think we need to do it a little bit better. So therefore, I ask for a favorable on HB 1250 as soon to be amended, or as soon, if you agree with the amendment. They'll be coming your way, hopefully in the next day or two.
That was my next question. Do we have those yet? But we'll be in touch then.
Yeah, I apologize. I only got this opposition from the Judicial Conference at 9:15 this morning.
Excellent. All right. Well, it's crunch time. We'll get to work. Thank you very much, Delegate Malone. And seeing no questions from the committee, that'll conclude the hearing for House Bill 1250. Thank you very much. Have a great afternoon. So committee will meet down here at 3:15 for a voting session.